So it's 3 minutes past. That means we're pretty much good for go. So thank you very much for all those that are joining me. People will join as we go, and there will be a recording available at the end, and we will put up so people can get to that. So thank you very much for joining me. I know your time is incredibly precious, so thank you very much for taking your valuable time. I'm hoping that today's webinar, part of our webinar series, is going to be hugely useful for as many of you as possible. And today we are going to be talking about trademarks and Amazon brand registry. So today's outcome, we're going to do an introduction. We're going to talk about intellectual rights. We're going to talk about trademarks and Amazon brand registry. And then at the end, there will be a Q&A. There is a chat function. So please, if anyone can put in the chat function, make sure you can see the screen. If you can just put that in, that would be amazing. Yes, I can see the screen, and yes, I can hear you, Andy. That would be super useful. And we'll have questions at the end. But if you've got a question as you're going through, I've had a couple via email already, so I've got those ready. But if you just put those in as we go, and then we'll ask all those at the end. So my name's Andy Hooper. I'm going to be your host for today. And I work here at Global E-Commerce Experts. And as I've already mentioned, this is part of our webinar series. Every Wednesday, we hold a webinar based on the tactics and strategies to help you to grow your Amazon or e-commerce business into the EU. We are here to successfully expand e-commerce sellers into the EU. That's what we do. That's what we're passionate about. And we are here to help you, take you, and make that a success. So anything we can do to support you that we're not doing already, we'd love to hear that feedback. And we'd also like to make sure any feedback, anything we're already doing. So thank you very much for giving up your valuable time. I know it's precious. We do have an Expanders Facebook group, so GE Expanders. You can find us on Facebook. It's a closed group for just our clients that can ask the questions about people that have already expanded. And that leads on to our hashtag Expander Series. Expander Series, you can do that. Now, we're well positioned because we've already expanded over 2,000 sellers. We have the advantage of seeing the data, both from a VAT point of view, from a 3PL point of view, and our account management services. So we're uniquely positioned to understand the European market so much better than the average agency that you might come across. It gives us a unique insight into what people are doing and where they are going and what actually works. So leading on to that leads me into our guest, William Miles, today. So William, let me just make sure you're unmuted. Let me just unmute you, ask to unmute. There we go. William, can you hear me?
Yes, yeah, hi everyone.
Perfect. And we can hear you, so that's a good sight. So William, do you want to just give a short introduction to yourself?
Yeah, I'm William. I'm a partner at a firm called Briffa, and we're a specialist intellectual property firm. That's all we do, that's our primary focus, and we've been going for about 25 years. We sort of specialise in both ends of the market, so we deal with brand new businesses, startups, SMEs, right through to multinationals and big international brands. So we've got a bit of experience with both, and we're always happy to help take any questions you have.
Fantastic. And what I want to say there is that we've recommended sellers to come over to William a number of times, and I've always been very, very happy. And that's where this then led on to, because one of the big questions we get all the time is, Andy, how do we get our brand registered? What do we need to do in the EU? How does that work? And that's why I thought this is actually pivotal. And what we see coming back to the data that we were talking about earlier, one of the things that we see that where people are really succeeding at the moment are the brands that are coming over and getting registered. They're getting, seeing that brand registry, they're getting it registered. They're able to excel what they're already doing on Amazon. They can have enhanced brand content, A+ content. They can get videos. They can get so much more out of their Amazon Seller Central account just by being brand registered. And that alone helps take your brand to the next level. I think that's really, really important. Now, when I knew William was joining us and being a solicitor and a partner in a law firm, I thought, what do all solicitors wear? Well, they all wear waistcoats and ties. So I thought I'd dress up for the occasion. I'm only joking, William, it's all right. So I wear a range of things. So it's strange, isn't it, now where we're all in this position where we all work from home. How often are you in the office at the moment?
Well, we've just started going back, so we're sort of in every other day. But even when we're in the office, we're not a suit and tie kind of firm. It tends to be with intellectual property lawyers. We're dealing with fashion and product design and music and film, and it doesn't suit our expertise.
Yeah, I love wearing a shirt and tie and suit. So I probably do it 2 days a week. I just,
Okay,
you know,
nice.
it's just something I like about it. I don't know what it is. But I'm flexible, like all of our sellers. No one really wears a shirt and tie.
Well, you need it for court. That's my only caveat. When you're in front of a judge, they
I
wouldn't.
just want to be very clear that I'm not going to court today. So just to hold my hands up there. Right. So that's great, William. Thank you very much. Now, what I want to just talk about here is this, as obviously we've already talked about, being part of our success pathway or our successful webinar series. We do have our success pathway. So when you're launching in the EU, we've got a solid structure and pathway that you need to go down. Now, actually, we're about to adapt this slightly more because there's a few things that as we've grown and developed, we believe there's a few more missing bits on there. And actually, what we're talking about today, the trademark, getting your brand registered, is actually a key part of that we don't necessarily have on there. We would recommend going forward, we're going to make sure that there's a hexagon. Yeah, I think hexagon on there with trademarks. So we're going to make sure that's on there for you as a seller, because it's, as I mentioned, that's absolutely crucial. Now, where that fits in that pathway is going to depend on your brand, because the brand is going to potentially, you want to launch. When you want to launch quickly. All right. So actually then going through the whole trademark thing, I don't want to do it until I've got my trademark and everything else, might actually slow things down. But you do need it along that pathway, and we'll come on to that, I'm sure, as we go through. So without any more further ado, that's enough from me. You really want to hear from William. You're no interest in hearing from me. So I am going to hand over to William. He's going to crack on through his presentation. If you've got questions, please put them in. But and we'll come back to me and William at the end. William, it's over to you. Is that all right?
Great. Thanks, Andy. Thank you for that. Right. So hello, everyone. So because I'm going to be talking about intellectual property generally, but specifically about trademarks, I thought it would be just worthwhile covering what I'm going on about. Intellectual property is actually an umbrella term, and people use it interchangeably, and it's very easy to mix up the different intellectual property rights. But IP is effectively the term that describes these different intellectual property rights. So we have copyright, designs, patents, confidential information, and trademarks. So I'll touch upon those top four briefly, and then I'll talk a bit more about trademarks, because I understand that's the branding, that's the most important thing for you guys in setting up your business. Right, so if we start with copyright, please, Andy. I should just say Andy's driving, so I'm going to have to communicate with him. So, right, so copyright. Firstly, the most important concept to get your head around, really, when thinking about copyright or even intellectual property generally, is that there are no rights in an idea. So I might have an idea to give a presentation about intellectual property. I have no rights in that idea. Anyone else can give a presentation about intellectual property. Only when I express that idea, when I put pen to paper and form that presentation, do I actually create some IP, and in this case, create copyright. It arises automatically. I don't have to go and get a certificate to prove I own it, but in the US, that is one exception. You can register copyright. And the big issue really, because it's largely an unregistered right, is ownership. Copyright is owned by the author, the person that created that work in the first place. The caveat to that is if that person was actually an employee acting in the course of their business, then their employer owns the copyright. But that causes all sorts of disputes because people are rarely clear about who the copyright owner is. And you end up with a situation like my monkey friend here. This photo is extremely famous in reference to copyright law, and it's called the monkey selfie. Basically, the monkey took the photo herself. The photo was set up by a British photographer. He did all the work. He trekked for days in the jungle. But because the monkey took the photo, when he went to exploit the rights and claim royalties and that kind of thing, PETA, the animal rights organization, decided to represent the monkey and claim that the monkey was in fact the copyright owner of this particular photo because the monkey was the author, pressed the little button to take the photo. That then caused a huge long dispute that went through the US courts, all to do with ownership, all to do with what happens with the copyright work and who gets the royalties as a result. Basically, the result was the photographer settled with the monkey, paid the monkey royalties, the monkey's charity was set up, and the jungle in which she lives is now super smart, super well looked after because she is found to be the copyright owner. I should add that's only as a result of a settlement. Effectively, the photographer ran out of money and gave up. But if it had gone to the US Supreme Court, they said they would have found that the monkey can't actually own copyright. So animals aside, it's important to make sure you're always clear about who's creating copyright works for you and who they actually belong to. But if you get copyright, it's a very useful right. It lasts for a very long time, being 70 years from the death of the person that actually made it up. So a useful right to have, and it applies to all sorts of works. So Andy, the next one I was going to talk about is designs. Designs basically protect the 2D and 3D shape of an article. We have designs here, registered designs in the UK and in the EU. They're pretty cheap and easy to get. In the US, it's also possible to register designs. They're a bit more expensive, a bit more complicated. There are certain rules around the type of drawings that you can use. But here's an example of one of our clients, Trunky, the ride-on suitcase. The founder registered all sorts of designs to protect this work. And that's the best way to protect that kind of product. People might not copy Trunky, the trademark, but they may well copy the shape of the product. And with a registered design, you have an exclusive right and a way of stopping someone copying you. They last for 25 years, so it's a good term, it's a good amount of use you can make. And they only apply to things that are novel. So you can't have a registered design for something that looks similar to something that already exists. It has to be a new shape, a new creation in order for it to be validly registered. But as I say, once registered, you can pick your jurisdictions and you can seek the places in which you're going to have your protection. Right, so that's designs. Next one would be patents. So patents is probably the intellectual property right that most people have heard of. It's the one that people ask about the most because people say patents sound incredibly good, particularly from an investment point of view. And they're extremely powerful as an intellectual property right. They give you a monopoly over an invention, a certain way of doing something, for 20 years. And they're very powerful in the sense that if someone infringes, you tend to have a pretty good course of action of stopping them. They're a registered right, so you can have your certificate, you can prove ownership, but they are expensive to secure because there's quite a high bar to actually get a patent. You have to prove that something's super inventive, super unlike anything else that's out there, which is called prior art. And if you go through that process of describing your invention, putting it, setting it out in a huge amount of detail with drawings and explanations, then you could get to the point of registering a patent. An important point to note though with patents is the invention must be completely new. So sometimes we have clients come to us and ask us, can we patent this invention? Can we patent this product? But if they have already disclosed it, if they put it on the market or shown people how it works, then no, you can't patent something. It has to be confidential right up to the point of making your patent filing. And if it has been out there, if someone else can find it, then it won't be a valid patent and it can't be something that's secured. The good example, certainly from a British brand perspective, is Dyson, the Dyson Hoover. This particular product has 20 or 30 patents governing all sorts of different inventive aspects of it. So the way the cyclone works, the way the blades work, the way that it moves, and all that kind of stuff are all defined and described in different patent registrations. And so people could infringe one particular aspect and make a completely different looking Hoover, but still infringe that particular patent. So it's a really useful right to secure, but as I say, quite an expensive one, quite a high bar to get through to registration. My next slide covers the sort of backup to patent registration. If you think, okay, well, I'm not going to spend that much money to get a patent, or the particular thing I'm trying to protect might not be patentable, particularly say if it's software only. What you can fall back on is confidential information, which is basically a trade secret. You protect confidential information most prevalently with an NDA, a non-disclosure agreement, and you ask someone to sign it. You say, I'm going to disclose this secret to you. In return, you need to sign this agreement to say that you're not going to disclose that secret to anyone else. The reason why it's so important to have things like NDAs is because confidential information is only a thing to the extent that that piece of information has been kept secret. As soon as it's disclosed publicly, even if it wasn't you that did the disclosing, it's no longer a piece of confidential information and it can no longer be protected with an NDA or anything else like that. So you want to create a contractual right to stop people from disclosing your secrets. The best example of a piece of confidential information is the recipe to Coca-Cola. This was so valuable to the people that started Coca-Cola back in the day that when they were trying to get some more funding for their fledgling business, they secured a loan based on the piece of paper that contained the recipe to Coca-Cola. It was so important that the bank kept it in the safe. They have that piece of paper still now in their own safe. And when they disclose the recipe to Coca-Cola, they make sure that everyone signs an NDA. It's not registered like a patent, so it hasn't run out after 20 years. So it means that they can keep that piece of confidential information way past the normal 20-year period of protection. But because it's not registered, Pepsi could try and guess the recipe. And Pepsi is allowed to make a drink that tastes and looks very similar without infringing any registered rights. But if Pepsi were actually given the recipe to Coca-Cola by someone who'd signed an NDA, then Coca-Cola would be able to sue someone for breach of that NDA. The obvious problem that Coca-Cola have is that no one person has enough money to pay damages for breach of that NDA. So you still have to be extremely careful about who you actually give that confidential information to. And you've got to see an NDA as more of a deterrent, but be more careful about disclosing that information and hope that the person you're giving it to will not disclose it in any event, irrespective of their contractual position. Okay, so that's just a whistle-stop tour of those other IP rights. And the main one I was just going to cover are trademarks. So trademarks, I think most people are pretty familiar with. They protect brand names, and they basically protect your sign, your signifier of origin. It's how you spot the difference between one t-shirt and another t-shirt. The trademark on that t-shirt is your clue. Say with a coffee cup, you know immediately this is from Starbucks. There aren't even any words on this coffee cup, but you know it's from Starbucks because it's got that signifier of origin on it, and it's a valuable intellectual property right to have. It's particularly useful because it can last forever. You have to renew trademark registrations every 10 years, but if you do, and if you carry on using it, you can just do it indefinitely. So brands can live for huge amounts of time and still be protected with a trademark registration. I should say that in the US, the use is far more strict than it is in the UK and EU. And in the US, brand owners are asked regularly to provide what's called statements of use, evidence that they are still using their trademark in relation to the goods and services that they've protected. In the UK and the EU, you won't be actively asked for this, but after 5 years, if you're not using a trademark, someone else can come along and challenge your use, and that third party can make you prove use. So the trademark registry won't look into it until there's a challenge. But you do need to keep using your trademark. If it's a word mark, your brand name, you need to make sure you're using it consistently. And certainly if it's a logo mark, you need to make sure that if you change your logo, if you update your logo over time, you file a new registration for that new logo, and you don't rely on the one that's no longer in use. The two big tricking points when trying to register a trademark, beyond whether, of course, someone else has already got that thing registered, is whether or not that trademark is distinctive and whether or not it's descriptive of the goods and services. So for example, if you try and register a trademark that's too generic, that is just lacking in distinctiveness, the trademark registry, wherever it is, will refuse you. The trademark registry's rationale is that you can't give a monopoly to any one person for a generic term because it would kill the market, it would kill the economy. So if you try to register the word speed in relation to cars, the trademark registry would say, no, that's too generic. Everyone in the car industry is going to use the word speed, so you can't own a trademark for it. Equally, you can't register something that's descriptive. So something like fizzy pop, if it's registered in relation to carbonated drinks, it's too descriptive. It just describes what you're doing. It describes what you're selling. And again, the trademark registry would say it's not fair for you to have that trademark, for you to own that monopoly. So when thinking of your brand name, when trying to work out what to register, you've got to tread the line between what sounds brilliant from a marketing perspective, and from a marketing perspective, that's normally describing what you do, and what is useful from a legal perspective, and that is really coming up with a distinctive brand name. So Starbucks is a good example. It doesn't describe coffee, doesn't describe coffee services, and it's distinctive in relation to those goods. So it is a tricky line. Lawyers are good at telling you what isn't registrable, and creative people need to come up with what is registrable. But if you do come up with a brand name that is distinctive and can be registered, you end up with a trademark. You end up with something that's really powerful that you can use to stop other people trading or running on your coattails. So it's always worth doing. It's always worth getting some advice before you commit to a trademark, before you commit to your name, so that you know you can actually protect it further down the line. Okay, Andy. I'm just going to give here some examples of trademarks. So typically, when we think about trademarks, we're talking about word marks, which would be the name in capital letters, and logo marks, which are some of the illustrations on the left. But certain big brands can get away with registering slogans, which normally are not very distinctive, but if you've built up a lot of reputation, you can get past that. Stylized words are really part of the logo. And we also have some brands that have registered music. Some brands have even registered certain colors. Tiffany, for example, Cadbury's chocolate here in the UK, certain really specific colors in respect of really specific goods could be registered if you can prove to a trademark examiner that you're such a big deal that everyone recognizes that color and associates it with you. Netflix has also recently started registering and has registered some moving pictures, effectively that N you see in their logo when you turn onto a Netflix program. And so the scope is quite wide, and you can register, for example, even 3D marks. So the Coca-Cola bottle is registered as a trademark. But for most brands, you're really thinking word or logo. Ideally, you get both. The priority should always be getting the word first, because that is the broadest monopoly that gives you the most protection. Okay, Andy. When we're registering a trademark, we need to pick what's called the classes of goods and services, or products and services here. There are 45 classes in all, and here I'm really talking about international classes. The US has a slightly different system, but it does recognize international classes. And anything a business does, whether it's producing a product or selling a service, will fit within these classes, maybe more than one, but certainly at least one. The classes 1 to 35 cover goods, so things like food and cars and tangible objects, and the classes 35 to 45 cover services, legal services, advertising services, that kind of thing. And so you need to pick, when filing your trademark, the classes that you're going to protect. The idea is that you can have brands in separate classes for identical marks that don't infringe one another. My best example here is, again, it's an English reference, but there is a chocolate bar company in England called Penguin. That's registered in one class. There's a publishing company in England called Penguin. That's registered in another class. And there is a clothing brand in England called Penguin. And again, another class. So they coexist on the register. They do different things. There's no real likelihood of confusion, even though they're using the same word. But if those goods or services drifted into one another, that's where there's likely to be an issue. And that's where you can have infringement claims and oppositions when someone's trying to register something. So again, this is a bit where you probably want to get some advice. You probably want to make sure that you have the correct things covered in your application, and the number of classes you pick influences the cost of the application itself. Okay. So in terms of infringement and how a trademark infringement claim is actually assessed, broadly speaking, there are 3 ways in which you could find infringement of a trademark between one and another. The first is the most obvious. If you've got someone else using a trademark that's identical to yours, as in it looks the same, it sounds the same, it's conceptually the same, and they've registered it, or they're using it in relation to identical goods and services. So if they, in terms of the same classes, if they're trading in that same space, identical mark, identical goods and services, that's a trademark infringement. That's clear and easy to stop. What's more likely, and where we spend most of our time litigating, is when you have another person's mark that's either identical or possibly similar. So it's not quite the same, maybe it sounds the same, or it looks the same, or it basically means the same thing, could be misspelled. And they're maybe not using it in relation to identical goods or services, but they are using it in relation to similar stuff. So for example, you might have protection for clothing, they might be using it in relation to bags, which is sold in the same shop and to the same sort of consumers. And if you can say that there's a similar mark, similar goods and services, and if you can show that these similarities cause a likelihood of confusion amongst people who are looking at both those things or buying those things, then you can still claim that's a trademark infringement. So it's a bit of a sort of assumption that some people make that, oh, it's okay if I just change this trademark a little bit, then I'm not going to be infringing. That's just not true. If you change the trademark in a way that is still confusing, then you will be infringing. And that's the type of claim that as I say, lawyers are going to argue about all day long. There is a third type where you can say, I've got a trademark and this person used a similar trademark, but they didn't actually use it in relation to similar goods. However, I am such a big deal, I have such a massive reputation that this use takes unfair advantage. So this wouldn't be like the Penguin example where you've got 3 brands coexisting on the register. This would be more like if I registered or sought to use the trademark Coca-Cola in relation to something completely random like garage services, car fitting services, that kind of stuff. Coca-Cola would say, right, well, we don't do that. We don't have a trademark that covers that. But because Coca-Cola is so well known, if someone saw a garage called Coca-Cola, they would still think there must be some connection to Coca-Cola. Coca-Cola must have branched out in some way, created some sister company or sister brand, and has somehow gone into car engineering and car services. And so it's a pretty hard claim to make, and you have to prove that you are extremely well known, you have a really big reputation. But it is, as I say, sometimes possible to stop third parties using your trademark or a similar mark in relation to something that you just haven't covered. So those are the 3 main heads for trademark infringement. And I'll give you just on the next slide a quick example of a trademark case and how they normally run. Here on the right, we've got the original brand owner, which is called Jack Wills. They registered a trademark, and in this case, a logo trademark for their pheasant, which is like a pheasant holding a walking stick with a hat on. They sort of sell to universities and they try and give like a sort of preppy kind of look and vibe, and they're a popular brand in relation to those sort of consumers. And they sell clothing. So what happened is that a department store in the UK called House of Fraser made their own line of clothing, and instead of applying the actual trademark to it, they applied their own brand, their own logo. And they created a logo that wasn't a pheasant, but it was a pigeon, effectively a different type of bird. It didn't have the walking stick, but it did have a bow tie, equally posh, arguably, and it also had the hat. And the way it actually appeared on the clothing is here. And the court found that, okay, the goods are identical. They're both being used in relation to clothing, and the marks are similar. But the question is, are they creating a likelihood of confusion? And it assessed the similarities between these trademarks, and it found that yes, they are sufficiently similar for a consumer to look at this product in House of Fraser store, pick it up and buy it, possibly thinking that they're buying what's called a Jack Wills product, a product from that company. And rather, they are actually buying something from House of Fraser. So there is a use of a trademark, and there is an infringement of a trademark by virtue of that confusion. And as I say, Jack Wills won the case, and it was quite a straightforward sort of claim for infringement. Okay, so I understand that you guys are effectively Amazon experts. You know all things about this platform. And so Amazon Brand Registry, it should be something that you've come across, certainly in the US before. But effectively, it is a platform-specific tool, something Amazon created. Amazon was suffering a lot in terms of use because people were worried about the source of the listings, the source of the products they're buying on Amazon. And whilst they saw trademarks frequently, consumers didn't always know where those goods were coming from and whether they were coming from the verified brand owner. So Amazon decided to create a tool where they said, trademark owners, submit your trademarks to us and we will verify you as the true brand owners. And once we verify you, we'll offer all these useful search and report function and will allow you to take down listings that aren't registered by you and been put up by someone else. And by using their tools, you're in Amazon's world, but at least you're registered and verified with Amazon, and it allows you to monopolize your market and actually enforce your trademark online and specifically in this platform more easily. So what I've got just set out on this next slide is probably your main question about the registry process is what do you actually need to get registered? If you're using Amazon Brand Registry in the US, then you will have your US trademark and you'll all be set up. But if you're moving into sales into the UK or Europe, then you'll want to register with Amazon Brand Registry in those EU member states, in those specific countries. If you are setting yourself up with Amazon Brand Registry in the UK, then what they will need to see is a UK trademark, a trademark that actually applies in this jurisdiction. The US trademark won't cover it, and you'll need a separate registration. It used to be that for the UK, you could show them an EU trademark, and for the moment you still can, but I'll come on to Brexit in a second, and effectively that position is going to change very shortly. So for the moment, really, you're focusing on UK trademarks for the UK. If you're setting up with Amazon Brand Registry in France or Germany or Italy, any other European member state, you'll want either a national trademark, so a German trademark, a French trademark, an Italian trademark, or you can show them an EU trademark. An EU trademark covers the whole of the EU in one single registration. It's very useful, it's very effective, and it's extremely cost effective on that basis. At the moment, an EU trademark covers 28 countries, and from the 1st of January next year, it will cover 27, and the UK, as I say, will have a separate right. In terms of what Amazon actually accepts, they accept both a word mark. So word mark can be seen here, Briffa, the name of my firm, just in simple capital letters. That's what a word mark looks like on the register. Or they would accept a logo trademark. And again, you can see Briffa's logo there. That would be acceptable for Amazon Brand Registry. The important thing is that trademark has to appear in your packaging. Amazon has to be able to see that and say, okay, yeah, that's your trademark. And normally what happens, and the way we sort of come across Amazon Brand Registry is we will have filed these trademarks and registered trademarks for our clients. When our clients want to sign up to Amazon Brand Registry, they submit the request. Amazon then contacts us, my firm, with a special serial number and says, we see that you're the representatives for this particular trademark. Please can you give this special password, this special number to your clients? We pass that on to our clients, and our clients are able to then go back to Amazon and say, yes, we've received this number. We can now prove by showing you the number that we're the verified brand. Amazon then accepts them into Brand Registry, and that is it. They're effectively covered. So it's a pretty simple process. All you need effectively is a trademark. You don't need to pay Amazon extra fees, and it can be done pretty quickly and pretty easily. The trademark does need to be registered, and Andy touched upon the fact that trademarks take a while to get registered. To give you an idea, for the UK, it takes about 3 to 4 months to get a trademark through to registration. And for the EU, it takes about 5 to 6 months to get through to registration. It is important just to start, just to get your filing in so that you have some evidence, and then you will go through the registration process. So the sooner you start, the sooner it gets registered. I just want to, as I say, touch upon Brexit as my last point. It may not be a big deal to you guys. It's a bit of a nightmare for everyone here, or absolutely brilliant, depending on your political outlook in life. But we are, or the UK was, part of the European Union. We have now left the European Union, but we are currently within what's called the transition period. So all the EU rights and all the kind of regulations that govern the UK being part of the EU still exist and will exist until the end of the year, until 31st of December, unless there's any extension, but it currently looks like there won't be. So after the 31st of December, the UK will not be part of the EU. And the question everyone has is, well, what happens to all the EU trademarks that have been registered? Previously, UK brands would just register an EU trademark because they know that that would give them protection already in the UK. The position is, and it's now been worked out, is that if you already own an EU trademark, if you have it registered and you're already the owner, then once Brexit is finalised, and at the beginning of next year, your EU trademark will give birth to a brand new and separate UK trademark. Effectively, your EU trademark will be cloned and it will be automatically generated and sit separately on the UK register. And that will all happen for free. So if you already have an EU trademark and that's already registered, you don't need to do anything to end up with protection in the EU and the UK. If you don't yet have an EU trademark and you're looking for protection in these sort of jurisdictions, the time is to effectively, where we are now, you basically need to apply for both the UK and both the EU trademark together, because they neither will be registered before Brexit. The UK might, but the EU won't. And you'll have to have your separate registration. So from now on, you effectively need to look at us as separate jurisdictions. The EU, 27 countries on one hand, and the UK, one country on the other, with those separate rights. And if you do that, you should have protection in both places. Okay, so that's it. And I'll now pass back to Andy, see if you have any questions.
That was super, William. Absolutely. It was crystal clear, really, really simple for people to understand. So thank you very much for your time. Let's get any questions you've got, then please put them in the chat function. As I said, I've got a couple that have come through, so I'm just going to start chucking those over. But I mean, a couple of ones I sort of had, you know, at the moment, we talked about UK and the EU trademarks. Can someone have, and this isn't really sort of barring an EU trademark, can you have a German trademark?
Yes. Yeah. So just as we can have UK trademarks and national trademarks, you can have a German trademark. You can have a French one and an Italian one. The sort of caveat to that, I suppose, is most European people, when they're going to filing a trademark, just go straight to the EU. And most people in the UK used to do that because it's just far more cost effective. You get 28 countries covered in one go, as opposed to just one. But yeah, as I say, that's going to have to change for the UK. We're going to have to file nationally. And yes, if you are coming to the EU and you're saying, I'm going to only sell in Germany, I'm only want to register with Amazon's registry, Amazon's platform in Germany, then you just need a German trademark. And that might be all you need to do to get registered.
Yeah, fantastic. Okay. I mean, but the economy of scale, you know, if you can get 27 all in one hit, then that's the way to go. I mean, I totally get that. And that saves you a whole load of paperwork in 26 other countries as well, because presumably there's a paperwork exercise in some of that as well. Yeah,
exactly. And there are different renewal dates, so you're renewing them both separately. You're having to do that every 10 years, and you're also managing them both separately in case you're going after one person, not the other. So, yeah, generally speaking, with IP, you're trying to look for your broadest monopoly. You're trying to look for your most possible coverage for your money, those kind of multi-jurisdiction trademarks are quite a good way to get it, just to give you that extra protection.
Yeah, fantastic. And you said 3 to 4 months in the UK, 5 to 6 months in the EU. Do you see that taking slightly longer as Brexit happens and make it more difficult? Or
it could well do. I mean, the EU will sort of, the EU timeline will probably stay the same because they're effectively just managing less. But the UK Trademark Office has a load of UK trademarks currently, and it's about to have all of the EU trademarks in the world replicated and put onto it over the next month or two. And they're hiring all sorts of extra people. They're freaking out a bit, and they're trying to work out how to do that. They seem to say that they know what they're going to be doing and they know how it's going to appear and how it's all going to work, but no one knows. No one has ever had to do that before.
Is it part of HMRC?
No, it's called the UK Intellectual Property Office. So it's a government registry. It sits in Wales, and it's its own thing. Every country has an intellectual property office. The US version is called the USPTO, and it's a government organisation. It is limited on funding and all that other kind of stuff. So it is going to be stretched massively. It's going to have to deal with a huge sea change in trademark registrations. And as I say, it's a bit of an unknown.
Yeah. Okay. Right then, let me move on to a question we've had come in. So Amazon mentions they recommend 11 different law firms to use their brand registry. What happens if one doesn't use any of these 11? And what if your brand, in this case, is still pending at USPTO?
So Amazon's requirements are you have a trademark. So how you go about getting the trademark is not really its concern. It can register. It can sort of recommend firms and attorney firms and US practices. But the net result is the same. As long as you end up with a trademark, that's what you need to show them. That's their eligibility requirement. My understanding is unless it's registered, they don't progress the application. So they need to get it through, or you might need to get it through the USPTO. And I appreciate in the US that can be quite a slow process, particularly if the USPTO is asking you to show evidence of use and that kind of thing. But the problem with Amazon is that they can be a bit computer says no. They're not very flexible. They're not very interested in individual cases. So it's just a case of getting your, hitting those eligibility requirements and getting your trademark through to registration.
Yeah, okay, fantastic. Now with the trademark on the packaging, where does that need to be? Does that need to be on the front, on the back, on the product itself, just the packaging? What does that need to look like?
Yeah, it should be in a prominent place. It does need to be applied to the goods, but yeah, it can be the packaging that wraps the goods. That is still effectively use, but it needs to be somewhere in a prominent place, somewhere where people can see it. And as I say, it's important to use your trademark consistently and make sure that you are showing use, because it's quite hard to rely on it further down the line if you can't really point to it and you can't really show someone where it's being used. The other thing is you'll see on packaging that sometimes you have the trademark and a symbol next to it. So you see TM in small writings or R in a circle. Basically, R in a circle has a legal meaning. That means a registered trademark. You can't use R in a circle unless you have a registered trademark in the jurisdiction in which you're selling your goods. So if you're a US brand, you've got a US trademark and you're suddenly selling in Germany and you've put R in a circle, you need to make sure you have a German or an EU trademark, quick sticks. You can, however, put TM next to it without any repercussion. TM doesn't have a legal meaning. It shows an intention to register, or that you plan to register, or even that you have registered. But TM in and of itself can be used in any event. R in a circle has to be used only when you have a trademark. And of course, because a trademark is a registered right, you don't actually have to put TM or R. You just have to register it. You have to make sure you have the certificate and it's viewable on a registry. But people do use that just to sort of as a warning shot.
I think that's actually a really key point. Actually, I'm not really necessarily we picked up on in the past, where you brands might have uploaded their label for to Amazon, for example, and they've come back and said, well, your label isn't compliant with the regulations. Now, Amazon is amazing in many ways, but what it's not amazing in is communicating what the issue with that label in this example might be. And actually, that's a great point, actually, that we've probably not highlighted and looked at, is that they could have a registered, a little R behind after it, but they might not have anything in the UK or Germany or wherever where they're trying to do that. And that might be one area they're being picked up on.
Yeah, I mean, you're with the R, you're claiming that you've got the registered right. And to a consumer in the UK who buys it in the UK, they're seeing it, you're claiming you've got a registered right here. And if you don't, you're making a misclaim, misrepresentation.
Yeah, I think that's really cool. And the TM thing, I've actually started seeing people start putting that behind their names on Instagram and things like that now. I mean, like, what on earth's all that about? I mean, like...
Yeah, well, look, people like the look of it. People, it's the same with the copyright notice. You can put C in a circle and claim copyright in a work. You don't have to. If you've got copyright in the work, you've already got copyright in the work. But it can be a deterrent. It can warn people off, and it can make people think twice before they copy you.
Yeah, maybe we'll start doing that on all of our webinars. Trademarked. There we go. Or is it copyright because it's media, it's content?
It's exactly, yeah. So copyright is covering things like pictures, text, photographs, graphic works, that kind of thing. And your actual brand name, that's where you'd have the R, the trademark.
So the good news is I bought this picture rather than this being out my window. So there we go. I've got the copyright for this, that I can use it for this purpose. There we go. It's my studio in London, you see. That's not quite like this. Anyway, okay. So I don't seem to have had any further questions. So, William, if people want to get in contact with you, what's the best way they can do that?
Yeah, I mean, email address or phoning us is best. I'm william@briffa.com. I think, Andy, you've got a quick slide at the end covers that. The way we work is when we speak to all new clients, particularly if they come through Andy, we offer free initial advice meetings. There's no charge for us to have a full meeting with you, discuss everything you need. And then what we do after the meeting is we send an advice note. That advice note will set out all the things you need to do. If we think you need to do something like register a trademark, we work on a fixed fee basis. So we quote the amount in advance. Only if you say yes do we actually do it. So it can be a really clear, really simple structure to use. And it's designed to avoid anyone worrying about fees and invoices turning up randomly in the post.
Fantastic. Okay. Well, that's amazing. So first of all, thank you very much to everyone who's listened. Everyone's going to listen on the recording as well. please get in contact with us or William if you've got any questions. We're here to successfully expand sellers into the EU. That's what we want to do. That's what these webinar series are actually for. So you can get the exact information from people like William to be able to make sure that you're making the most out of your expansion into Europe. So William, thank you very much for your time. I know it's precious and hugely valuable. So thank you very much. We really appreciate it. Any further questions, then please put them through. And outside of that, we'll leave you all to it. So have a wonderful evening. Stay safe, look after yourselves, and we'll be back for another successful webinar series next week. Thank you. Thanks, William.
Thank you. Thank you.